this case that we're talking about right now is another case that we had been watching very closely. It has to do with permission to carry a gun in New York. And New York required a permit. And to get that permit, you need a reason. You need a valid reason. You can't just say, I'm scared in the city because crime rates are going up. That's not a reason. But there are other reasons. And essentially what we're getting from the Supreme Court is New York can't do this.
Right, exactly. So I'm just looking at the opinion as we speak, and I think one of the key things is that Justice Thomas is saying that the Constitution provides you with a right to carry a gun in self-defense. And so the problem with this law was that it particularly just what you just said, which is that it said that self-defense was not enough in order to justify a permit to carry a gun outside the home. So in that way, it is somewhat limited, because what it isn't saying is you have a right to carry a gun in all places at all times, no matter what. It's saying that self-defense has to be taken into account. Somebody's right to self-defense is written into our Constitution.
We want to bring in another voice. Joseph Watcher, there you go, over here. You are the co-director at the Duke Center for Firearms Law and a professor of law at Duke University. So glad you're here. You've had a little more time. Poor Rebecca. We just threw her out there on TV to start talking about this, and she's skimming through very quickly. But you've had a little more time to sort of delve into the arguments on both sides. So what are you getting from the decision? Is this broad, or is this a measured sort of incremental shift?
Well, I think it is broad, and it's broad in a way that constitutional lawyers and professors are going to be especially interested in, because what the court has done here is not only strike down New York's law, but actually change the way that other gun laws are going to be evaluated under the Second Amendment. Essentially, what Justice Thomas's majority opinion does here is say that the contemporary costs and benefits of gun laws don't matter nearly as much, maybe not at all, as compared to their rootedness in history and tradition. This is an opinion which I've only begun to digest because it's quite lengthy, but almost all of it is about historical sources. Reading here about medieval England and the colonies back in the 1700s. This is a real turn towards what seems to be a super originalist approach to interpreting the Second Amendment going forward. So I think it's very important, not just for New York, but for how other gun laws are going to be evaluated as well.
So let's talk about that, because I just asked Rebecca whether or not the justices take into account the real world implications of their decisions. What do you see as kind of the ripple effect here?
It's going to be really interesting. I mean, this opinion is almost saying that we can't look at those real world contemporary impacts. I mean, I think Rebecca's exactly right. The justices can't help but notice what's happening in the world. The most recent CDC data say we hit an all-time high for gun deaths in this country just 2 years ago. They can't help but know that. But the way that the court is describing the doctrine here, and again, I think it's going to take us a while to kind of parse the opinion, is saying, no, we set our constitutional law based on historical sources, based on the way the framing generation and maybe some earlier generations did, but not based on the contemporary effectiveness of gun laws. Now, as far as the ripple effects going forward, I'm not sure how lower courts are going to implement that. It's hard to find, for example, historical rootedness for, the current law prohibiting guns on airplanes. It's not something the framers thought about in 1791 for obvious reasons, or guns in daycare centers, or gun possession by people convicted of domestic violence crimes. Those aren't laws that were on the books in 1791. So there's going to be a lot of work about new historical sources, reasoning by analogy, and really we're in a whole new era here of Second Amendment doctrine, it appears.
So, Professor, what is your expectation for what will happen next because of this decision?
I think we're going to see a lot of litigation. The Supreme Court, when it announced this sort of a new version of the Second Amendment right in its 2008 decision in District of Columbia versus Heller, kicked off a wave of constitutional litigation, more than 1,500 Second Amendment cases in the last about 15 years. I think we're going to see a lot of those cases essentially be re-litigated because courts up until now have been upholding gun laws largely on the basis that they are sufficiently tailored to sufficiently important government interests. But based on a quick glance at this opinion, it seems like that's no longer the test. And so courts will be confronted, I think, with renewed challenges to gun laws that, at least till now, we've taken for granted as constitutional.
What about the dissent? I don't know if you got a chance to take a look at the dissenting argument, whether or not they went deep into the historic crates to bolster their argument.
It's an interesting question. I haven't yet read through. Justice Breyer wrote the lead dissent. He wrote dissents in the court's prior major Second Amendment cases, Heller and McDonald. I would expect it's probably going to be more of the same. In his Heller dissent, he both cited to history and to contemporary evidence about the effectiveness of gun laws. The history, he says, shows that governments have long had the authority to regulate guns, especially in public places, and the contemporary empirics show that they can do that in effective ways that respect the right to keep and bear arms and save lives and keep people free from terror. I expect we'll see more of the same in his dissenting opinion. I should also note there are 3 concurring opinions in this case, too, from Justice Alito, Justice Kavanaugh, and Justice Barrett. So I haven't read those, but that would probably signal that there's a lot left to be resolved. Usually those opinions are used to sort of signal, here are some questions that the majority doesn't answer. All those justices joined the majority, but then they felt the need to write something additional above and beyond.
Now, this is all about legal interpretation at the end of the day, but we do have a predominantly conservative court. You know, from 1 to 10, what level of surprise do you have on this decision?
I'm not surprised by the immediate results. I had thought that the New York law, at least in its current form, was going to be struck down, so I'm not surprised to hear that, to see that happen. I was a little surprised, I am a little surprised to see the court go so thoroughly in favor of this new approach to evaluating Second Amendment challenges. It's what's known often as the test of text, history, and tradition, and I think it represents a real turn, not just with regard to gun rights, but just with regard to constitutional methodology. This is a court apparently made up of now a solid majority of justices who believe that originalism, that is sort of a belief in the power of history to resolve contemporary constitutional disputes, holds sway. And maybe that bodes for changes in other areas of constitutional law as well.
So, Professor, I'm sure you know about what Congress has been debating in terms of gun legislation, right? This bipartisan bill that includes enhanced background checks for people both sort of under the age of 21, what they call the boyfriend loophole. If somebody's been convicted of domestic violence, they should have limited access. And these red flag laws that if you are somebody who's deemed to be violent, they can limit your access to guns. Does this ruling bleed into any of these in any way? Could this ruling have an impact on what we're seeing being debated in Congress?
I'm certain it'll have an impact in terms of people will raise Second Amendment objections to some of the things that are in the Senate bill. I would say that, as Second Amendment law stood an hour ago, anyway, nothing I saw in the bill raised any constitutional red flags under the Second Amendment. I'd have to digest this opinion a little more to say more about it. But most of what the Senate's talking about, I think, is nowhere near the outer limits of what the Second Amendment says the government can do. Most of those changes are quite marginal. They're not the kind of things that have been struck down by any courts, again, until now. But I think we'll have to see, how advocates and how judges and how scholars kind of reason by analogy. Like, take the red flag laws, the extreme risk laws. That's not something that the framers adopted in 1791 or used in 1791, but they did have the understanding that guns could be taken away from people who were dangerous. So maybe that's how the analysis works going forward. It's certainly going to raise a lot of questions, but I don't think there's anything in the current bill that would set off any constitutional problems.
You also wonder what this means for New York State. We have a statement just posted by the governor, Kathy Hochul. We can pull it up on screen for our viewers. Responding to this SCOTUS decision, quote, "It is outrageous that at a moment of national reckoning on gun violence, the Supreme Court has recklessly struck down a New York law that limits those who can carry concealed weapons." She goes on to say, "In response to this ruling, we're closely reviewing our options, including calling a special session of the legislature. Just as we swiftly pass nation-leading gun reform legislation, I will continue to do everything in my power to keep New Yorkers safe from gun violence." That statement from the New York governor moments ago. What can New York State do now?
Well, I haven't yet put my finger on the part of this opinion which says, as I expect some part will, that states and the federal government and local governments still retain tools to combat gun violence. That's certainly something the court has said in its prior decisions. I suspect it'll say so again here. One thing that was prominent at the oral argument, and which I suspect will come up again, is the use of locational restrictions, sometimes called sensitive place restrictions. So, for example, prohibitions on guns in maybe Times Square on New Year's Eve, football stadiums, schools, government buildings, and so on. The court's prior cases have made it clear that the government has authority to do that, and at oral argument, certainly the justices seemed to want to re-endorse that principle, although it's a hard one to articulate. What defines a sensitive place? What counts as a sensitive place?
That it only affects 6 states.
So people may have seen or heard Rebecca's voice sort of bleeding through,
Live
which is
coverage,
perfect,
folks. You're watching
Rebecca,
live
because I
TV.
actually was going to pivot to you, right? Because you've been sort of getting a chance to kind of absorb some of this material now. And so I was going to sort of ask you, what is jumping out to you now that you've had a little bit of time, a little more time to digest it?
Okay, so first of all, let me just say again, this is a major decision. And as you were just saying, it strikes down New York's law and suggests that there is an individual right to own guns for self-defense, which is itself a huge statement. However, it does seem that as I was looking through some of the concurrences, that Justice Kavanaugh said that this will only affect 6 of the state laws because there are other laws that are framed differently. The thing that was particularly egregious about this law, the Supreme Court says, or Justice Kavanaugh says, is that it said that the state may not issue a license unless somebody has some reason other than, and self-defense does not work. There are some other states that frame their laws differently in terms of shall issue. So it says that the state shall issue in certain circumstances. And those state laws seem to remain intact, at least according to that concurrence.
Oh, that's so interesting. So those state laws are just a little more flexible, and that makes all the difference?
Right. And again, I'm skimming. So just bear with me. But I think so. That I think that what the court is really objecting to, and what the concurrence clarifies, is that this is a state that said you cannot issue a license, even if somebody says that that person needs the gun for self-defense. That is not allowed under this current decision. But you can have other state laws, and as we read through, we would figure out, and I'm sure others are rapidly trying to figure out how you could draft a law in order to survive constitutional scrutiny. But what this concurrence gives us a hint to is that a state can suggest that you must issue licenses in certain circumstances and leave out self-defense, and that would probably survive scrutiny.
So maybe that is the answer to your question about what can New York do when the governor says, we're going to go back to the legislature. Maybe it's a matter of sort of tweaking some of the wording to fall within the bounds.
Which is incredible at the end of the day, because so many of these incredibly significant Supreme Court decisions come down to interpretation of text, what words do and don't mean, and which parts of state laws go beyond what the Constitution asserts.
100%. But just people should not lose sight of the fact that no matter what, no new legislature can draft a law saying that somebody cannot have a gun for self-defense. And that is, bottom line, extremely important and, in a certain way, revolutionary about this decision.
It's really interesting. Is the professor still there? We lost the professor. Okay, so we're just going to tell everyone what is happening right now. You can see that's a live look at the Supreme Court. We are awaiting a number of decisions from the Supreme Court. We just got one in the last 20 minutes, half hour or so. That was one of the bigger ones that we were waiting for. It had to do with access to guns in New York. New York requires people to have a permit to carry a concealed weapon. You need a reason that New York State approves of. One of those reasons cannot be self-defense. But the Supreme Court has indicated that that is not, and Rebecca, you can sort of help me out, that is not a strong argument for not allowing someone to have a permit. That you can't say you must have these lists of reasons in order to carry. This is my non-legal jargon.
Yeah, totally. There's one unconstitutional thing that we can take out of this opinion, which is it is unconstitutional to tell somebody you cannot have a gun because you only want it for self-defense. And so that means that there is a constitutional right to carry a gun for self-defense outside of the home. Now, what other sorts of restrictions that the constitutional rights are never absolute, right? I mean, you have a right to free speech, but you can't, you can't use your speech rights to, for instance, I can't rally a crowd to go, kill the governor or something like that. So there are limits that will be acceptable. And so what are those limits? Will it be okay for the state to say, yes, there's a right to carry a gun for self-defense, but not in a crowded subway, right? Those things still remain. But one thing that we know is that there is this constitutional right. It is written now into law that this is a constitutional right to carry a gun outside your home for self-defense. It doesn't have to be absolute, but it's strong because it is now read into the language of the Constitution.
We have our Duke professor still with us, connected and listening into this conversation live in real time as we digest the Supreme Court decision and bring it to our viewers around the world here. Professor, I'm just taking a look at some of the immediate online reaction to this, and those supportive of gun limitations seem upset. What do you make of the decision, and for those who are upset by the decision, what does this mean for them?
Well, I mean, I think what it illustrates is we're just in an extraordinary moment when it comes to the balance of gun rights and regulation in the United States. We're on the verge of the first major federal legislation imposing gun regulations in 30 years. We have the first major Second Amendment decision sitting here in front of us in the last 10 years. And gun deaths hit an all-time high, according to the most recent CDC data. So everything is coming together in a pretty extraordinary way. And I think there's going to be people who are upset on sort of all sides of this issue. I do think, having looked through the opinion a little bit more now, that the court is clear that there are still steps that states and local governments and the federal government can take to reduce the harms of gun use and gun violence. And some of that might include permitting requirements, just not the kind of permitting requirements that New York had here, which the court said were simply too strict. And it may still be that states, for example, can impose the kinds of shall issue licensing restrictions that we were just talking about, which are more objective, tend to include things that are more like check the box as opposed to the kind of more discretionary system that New York had. So I think there are still going to be pathways open, including in New York. It's just that this particular kind of law, which, as the court says, only exists in, depending on how you count it, 6 to 8 states, may be called into question. Now, I should say those are 6 to 8 big states. It includes California, New Jersey. If you put them together, it's about a quarter of the American population lives in those states. So this is still major.
So then what happens in the meantime? You know, we've been talking about Roe v. Wade and how many states have put in these trigger laws that the second Roe v. Wade is overturned. They have laws that will either immediately go into effect or will go into effect in sort of 30 days. I'm trying to understand like what this means for people in New York right now. What happens immediately if you want to carry a gun, I don't know, down Fifth Avenue?
Well, it's going to be really interesting. And I assume that right now, and we already saw the statement from the governor, which you showed the viewers a few moments ago, that the governor, the legislature have already sort of, I think, seen the writing on the wall that this law as currently drafted was going to be struck down. So I wouldn't be surprised to see some new set of differently tailored restrictions put into place. I don't read the court here as saying that from now on, all states are permitless carry, meaning you can just buy a gun and start walking around in public with it. About 20 states have adopted that by statute. That is, they've done away with their own permit requirements. But the court here is not saying that the Second Amendment requires that. Some states have chosen that, and we've seen actually remarkable deregulation of public carry over the past few decades. But that's all just a matter of state political choice. It's not something that's compelled by the Constitution, even after this morning's decision.
We have a statement out from Senator Gillibrand. Today's Supreme Court ruling, which guts state concealed carry permitting laws, is not just irresponsible, it is downright dangerous. Our nation is in the middle of a gun violence epidemic, and instead of working to protect our communities, this court has made it even easier for potentially dangerous people to carry concealed handguns in public spaces. Rebecca Roiphe also with us here, our legal analyst, to digest and understand all of this. What about that argument the senator is making?
I think it's a very good argument, but it's not one that's going to convince this particular Supreme Court, and especially not Justice Thomas, who is rooting his decision in history, tradition, the language of the amendment, and he is, to the extent that he's thinking about gun violence, not taking that into account. And so this is a different way, a politician's way, and a politician who is more ideologically on the left way of countering that this decision is bad, but it is not, it's almost like they're speaking different languages.